The legal battle between the Ghana Police Service and leadership of the Fix the Country campaign came to an end today with a major ruling. But prior to the ruling, some other major developments took place in court today. Now I'm going to bring our court correspondent Sixtus Dong Ulo to essentially walk us through the things that transpired today in court. So first of all, we know that the ruling was given in with regards to the AG representing the police in this case. Can you talk to us about that?
Lawyers for the Fix the Country demonstrators had argued that, look, the police service as an entity should be arguing this particular injunction because they brought it, and in line with the Public Order Act, they should be the ones seen to be arguing this particular matter. In court on Friday, the Judge Justice Ruby Aite said that indeed the Attorney General, per the provisions of the Constitution, is the one who should be representing the police in this particular matter. By that ruling, it meant that the Attorney General, Godfred Yeboah-Dame, could then go ahead to argue the injunction application in the name of the Republic against the organizers or conveners of Fix the Country demonstrators.
Which is the substantive case. Now, in that case, what were the key arguments of the two sides?
We can again start with the argument that was made by the Attorney General, Godfred Yeboah-Dame, who represented the applicant in this case, the applicant being the Ghana Police Service. He said that the entire prohibition is premised on EI 37. So specifically, this talks about the imposition of restrictions. And if you go through it, it talks about the kind of events that the restrictions would be imposed upon. And amongst those events is what is described as large political gatherings. And so the Attorney General quoted the aim of the demonstration as prescribed by the organizers themselves. So he said that they were going to march against a string of broken promises by successive governments. And based on this, the Attorney General concluded and submitted to the court that indeed this has been demonstrated or shown to be a political gathering that was going to be embarked upon, and so prayed to the court not to allow it to happen. Again, if you look at the lawyers of the Fix the Country demonstrators, argue that, look, if you look at the application itself, the injunction application itself, it is moot, simply meaning that it is belated, because the application is seeking to injunct an event that was supposed to have occurred on the 9th of May. Again, on the point of large political gatherings, he was surprised, asking that who defines what large political gatherings could mean, or how could the Attorney General purport to be defining large political gatherings. And he compared it to political rallies that happened in the run-up to the 2020 presidential and parliamentary elections. If you would recall, immediately after that, there was a rise in COVID-19 cases, and we had two communications. He mentioned or referenced the communication from the Information Minister, Kojo Opong Nkrumah, and the communication from the man who has been at the helm of this COVID-19 fight all this while, the Director General of the Ghana Health Service, who had both said that we could not have attributed, or they could not have attributed, the rise to COVID-19 cases to the political campaigns that were held in the run-up to the elections. So the lawyer compared those rallies to the march that the Fix the Country people intended to go on, and submitted to the court that the two are simply incomparable. If the political rallies could not cause the spike in COVID-19, how would this demonstration do so? And so when Justice Ruby Aite came to give her ruling, she agreed with the submission that was made by the lawyers for the demonstrators. She agreed with the point that the application was belated, and so there was no point. She could not have possibly been invited upon to give judgment on something, or to seek to stop something that has already long passed. And so she said it is belated. Importantly, she also said that if the demonstrators were still minded to, or if they wanted to go ahead to organize another demonstration, then they would have to go through the process as outlined by the laws before they would be able to do that. So essentially, this is what we had in court.
So which means that if indeed they want to go ahead and embark on a demonstration, they would have to go back to the police, seek some kind of support to be able to hit the streets.
Exactly. Essentially, it means that if they want to demonstrate, they have to go back, the same Public Order Act, the same notification to the police. Possibly you will get the same response from the police based on the same law.
Thank you so much. That's my colleague Sixtus Dong Ulo, essentially breaking everything down for us when it comes to what transpired in court today. So the ruling has been given, but as to whether or not the conveners of the Fix the Country campaign would organize a demonstration, we are yet to know that. You're still watching The City Newsroom.